Reg B actually defines applicant discrimination, and it says there to treat an applicant less favorably than other applicants. Can we do that? Yes, we can. In fact, you do it all day long. I'm gonna split some hairs here in just a bit, but you've got a whole loan policy and procedures and a rate sheet that you use to put people in different buckets. Whether you get our best credit, you get credit, but it's not our best. I'm not sure we can do anything for you. We might make an exception. And then we got people we say no to, right? And we use all kinds of information to slice and dice people and legally discriminate them. Okay. And so that kind of knocks out letter A and B. Letter C, what we need to strive for is steering clear of what you see in letter C, the red, illegal discrimination. Okay. So back to legal for a moment. Okay. There's a laundry list there, bottom half of page number 8. Now, if you look at letter A through G, you might be kind of taken aback and going, wait a minute, I know I've seen some of this somewhere where the regulatory agency said, oh, you can't use that or don't go there. And I'm going to point out letter E, criminal records. Diane, what was about a year ago, maybe 2, the CFPB in their supervisory insights, they brought to the attention that if you are using criminal records as a way to potentially determine whether somebody gets a loan or not, that could be a basis for illegal discrimination. They were really stretching things there. They were trying to use it as a proxy to get to a prohibited basis characteristic. And a lot of times that's a stretch. So criminal records are not a protected class. In fact, none of these things are: education, economic class, social membership. Now, could they be closely related to or tied to a prohibited basis characteristic? Yes. That's why you see the note at the very bottom of the page. Okay, while these things are all fair on the surface, if they can somehow be tied back to a prohibited basis characteristic, then we have something to talk about. But by themselves, these things are not going to get you in trouble from a fair lending standpoint unless they're tied back to something else. I want to call attention to letter F, loan policy and procedures. This is what we do day in and day out: loan to value, debt to income ratios, debt service if we're talking about commercial loans. These things are okay so long as they're not tied back to a prohibited basis characteristic. Let me give you another example. So credit score, you'll see that in F5. Okay, we probably all use credit scores. They maybe aren't used as much on the commercial side, but I think this will be helpful in trying to illustrate what I'm talking about here. It's okay to use credit scores. They are not illegal discrimination. But if you're tying credit score to marital status, for example, let's say if you have a joint applicant for a business loan, and it's 2 individuals that aren't married, okay, and it's not a corporation, not something like that. And so you say, well, we're going to take the first person listed on the application's credit score when they're not married. Okay, but if they're married and applying for a business loan, we'll take the higher of the 2 scores. Yes, you're using credit scores, but how did you slice and dice them? Okay, using marital status, that's not okay. And that's where, yeah, you may be thinking that you're using something that's okay, but if it's tied back to something that's not, one of the 8 or the 6, that's where it presents a problem. So we need to dig through the layers sometimes.